So, a question that a lot of people ask is what's the difference between how divorce works for men versus women? And the answer is not much. Didn't used to be that way. Long time ago, a woman could not get a divorce without the man's permission. Imagine that. More recently, but some time ago, there was a general perception that women had an advantage because the courts had a predisposition to award children in custody to the wife, to the mother, and not the father. And that the father would get stuck with alimony and child support, and that would all go to the wife. Times have changed, and there is much less. Ideally, there's no difference. Is there still vestiges of difference and prejudice? Absolutely. And that will depend on the court, on the judge. But for the most part, the ideal, the law, is that there is no difference. So, and your lawyer that you're working with, if they perceive there to be a bias, they should and can do something about that. So is there a predisposition to children being awarded to one side or the other? No, there's not. In Colorado, there is a predisposition to awarding parents equal parenting time, so long as the logistics of the relationship, in other words, the parents still live close enough to get to one another, support there being a relatively equal or equitable share of parenting time between the parents. And the courts expect both parents to promote a positive relationship between the children and each parent. Can it be awarded unequally? Absolutely. If one of the parents demonstrates that they aren't fit to be a parent, to have the children overnight or at all, through abuse or through poor parenting decision making, then parenting time can be awarded unequally. If one of the parents shows that they are unwilling or unable to promote a positive relationship between the children and the other parent, that could result in less parenting time and even sometimes no parenting time with that parent. These are unusual and never or almost never permanent. So in other words, although unequal parenting time might be awarded at first, the parent who got the less time can come back and ask for that to be revised, to be modified after they have remedied whatever situation caused the parenting time to be unequal. And so goes child support. Child support these days is a calculation done by a very specific formula set out in the law that the lawyers in the case and the court in the case have to follow. Now, if two parents agree to deviate, a deviation can be held, but the court has to find that if the guidelines, these are called the guidelines, the calculation that I just talked about, if the guidelines are if the child support is going to be different than the guidelines, the court has to find that the parties have proven to the court that that is what's in the children's best interests. So, because child support really is a right of the child or the children, not of the parent who receives it or of the parent who gives it. It's a right of the children. And so the court has to find that it's in the children's best interest. What about marital support, alimony? Is that a differential between spouses? And the answer to that, again, is no. Once upon a time, absolutely. But no, it is calculated based on relative income between the parties and their ability to earn income going forward. So if there are economic disparities, one party, the wife, earns more money and has a history of earning more money than the husband, then it is likely that the wife will pay marital support to the husband. And the same goes in same-sex marriages as well. It's the same exact calculations that really just go to the economic history, what the person has made, and the economic capability, what the person has the capability to make. So just because you've been unemployed for a number of years doesn't mean that you're unable to make money. And the marital support is based on how able you are to make money, not how much money you're actually making right now. So much like the other aspects of divorce and how women and men differ or fare in the outcome of divorce, the question goes to who gets the house. And the answer is quite often nobody. These days, houses and the cost of maintaining a house is occupying a larger and larger portion of the joint marital income. So it becomes harder and harder for one party to actually maintain that house. And so houses are generally considered as all other assets to be equitably divided between the parties. So they go into the pile of all the other stuff, and some stuff gets awarded over here and some stuff gets awarded over here to end up with an equitable result, a fair result. And so sometimes one party wants to keep the house. Sometimes one party is going to be awarded the majority of time with the children and want to keep the children in the house. But as to whether it's the wife or the husband, that is no longer a factor. It is a factor of whether or not one party can sustain the house going forward. Of course, this is considering that the house is marital property, and whether one party is willing to sustain the house going forward. Sometimes in those circumstances, the party keeping the house has to buy the other party out of their equity in that house, and that becomes part of the equitable distribution. But no, there's no prejudice or bias towards husband or wife or higher earning person or lower earning person as to who gets to keep the house. It's just part of the equitable distribution of all the assets and debts in the marital estate. One of the other questions becomes, what about stay-at-home parents? How do they factor in? And the answer is that it is a very difficult subject, because sometimes the economics of the situation are such that one party was able to be a stay-at-home parent only inside the context of the marriage. You've heard the phrase, two parties can live as cheaply as one. It's not entirely true, but it's partially true. When you're taking two people who shared a lot of capital assets, who shared a house, who shared a vehicle, who shared pots and pans, who shared utilities, who shared the heat, who shared the water, who shared all these things inside one household. And now you create two households. These parties, no matter how equitable the split might be, are not able to sustain very often the same level, the same standard of living. And part of that standard of living is being a stay-at-home parent. So even when both parties agreed that one of them would be a stay-at-home parent, that just might not be economically sustainable post-divorce. In circumstances in which it is sustainable because of an award of marital support, then the court might consider that the stay-at-home parent has a lower income based on the parties' agreement for them to be a stay-at-home parent. But if it is not economically sustainable, the fact that they've been unemployed outside the home because they've been a stay-at-home parent is not taken into consideration. Their income is not judged to be zero. Their income is judged to be what they, with their skills and work history, are capable of earning in today's market, whatever that might be. So the fact that one's been a stay-at-home parent is not dispositive, doesn't decide whether they can continue to be a stay-at-home parent, because quite honestly, sometimes the economics no longer work out.